going to start this panel, Privacy in Latin America, Towards Regional and Global Convergence. This panel is organized by European Commission and the Ibero-American Data Protection Network. We're going to address the issue of convergence in a region which has been the region where maybe data protection has developed the most on the last 10 to 15 years, where in the beginning of in the year 2000 we had just one country data protection legislation enacted, and now we have an almost majority of countries and very big economies in the region all now have data protection legislation enacted. And the interesting phenomenon of convergence is working in a particular way, sometimes in Latin America, and now we have panelists from several Latin American countries which will address their specific conditions. And I give pass the word to Manuel Sanchez from European Commission, who will moderate the panel.
Thank you. Thank you, Danilo. Good morning, everybody. And thank you for being here. Today is still early in the morning and outside is snowing, so I think also it is a good opportunity for sharing some time with this very important group of speakers we have here today. Last year, on 25th May, when the GDPR became applicable, this happened just shortly after, 1 year after the adoption of the Ibero-American Data Protection Standards by the Ibero-American Data Protection Network. This is a network that, let's say, groups all data protection authorities from Ibero-America and some authorities from Europe. This was, in a way, this was not a coincidence. It reflects how much we have in common in this area and how much can we do together to ensure global convergence in data protection. In that regard, we have seen in the last year many new developments. Brazil adopted its first comprehensive data protection law last summer, and even though when we have provisional measures issued by the former President Temer, something maybe we will have the opportunity to discuss a bit with Danilo. Chile amended his constitution to introduce the right to private data protection as a fundamental right, and also announced the creation of an independent data protection authority in the framework of the law that they are developing now, to modernize the system law. Argentina, where President Macri tabled a draft law in last September, and recently was also approved by Congress, the accession to Convention 108. And also, we could also mention Uruguay that recently approved some amendments to the current law in order to introduce some interesting developments. In our view, this shows how regional integration, global convergence, can meet and can complement each other, and in this way, bringing new opportunities. And this convergence is based on common principles. We could easily talk of some of them, and you know that maybe the principles of a modern data protection law is an horizontal law, a set of common agreed data protection principles, enforceable data subject rights, and the system of independent data protection authority. And this convergence is contributing to the closer relationship between Latin America and the European Union that are already tied together through strong political, commercial, and cultural bonds. It may also bring very tangible benefits by facilitating trade as well as cooperation between public authorities that both increasingly rely on the exchange of personal information. We are convinced that convergence in data protection standards nowadays pays off, as shown by the recent adequacy arrangement with Japan that has created the world's largest area of free and safe data flows. And even this convergence can also facilitate, and this is also important, more effective cooperation between privacy regulators. One of the lessons learned from the recent scandals is that we need to get serious about enforcement. In that context, the role of data protection authorities is more crucial than ever, and now our speakers will illustrate that on that point. So this is why regional international cooperation is so important. It gives a unique opportunity for enforcers to exchange experiences and best practices, is what we are doing today. And simply I would like then to introduce our first speaker, the Dr. Laura Nahabetia Brunet. She works for the Unidad Reguladora y de Control de Datos Personales in Uruguay, and I will ask her to talk a bit about the situation in the country and also on the more recent developments in data protection. Laura?
Thank you, Manuel. Good morning for all of you. What I have to say is what I'm going to say now. To the extent that the focus of public action is a person, human beings cannot be considered as passive, mere recipients of political decisions. As we have highlighted, defining a person as the center of government action means not only, or even primarily, qualifying the person as the center of public activities, but also considering him, her, as the key player of political life. That concept alone exemplifies in the clearest manner what I believe is good governance in a democratic framework. To say that the freedom of citizens is the primary aim of political actions means, first of all, improving the constitutional, political, and legal mechanisms that define the rule of law in its role as frame of freedom. But secondly, and even more importantly, it means creating the conditions for every man and every woman to find the perfect place in which they can freely play an active role, developing their personal choices, that making a creative contribution to the development of the society in which they are integrated. Such conditions created, the actual exercise of freedom depends only and immediately on each and every citizen. Good governance, good administration, has to seek precisely the generation of an environment in which each citizen can exercise its right to freedom sympathetically. The big challenge for governments is to ensure that the laws that have been enacted possess a margin of effective enforcement, so that citizens come closer to the administration, producing a new political legitimacy. Responsible government seems to be the center of political dialectic as a mechanism to build a renewed trust of citizens in the governments. Some developed countries had tried to provide better and personalized services to citizens. However, a responsible government does not develop fully from the perspective of politicians, but from knowing what citizens and businesses understand and require. We share the statement indicating that democracy requires transparent and accountable operations by the public authorities. This means that citizens must have the legal ability to know at all times the behaviors of their rulers. If not, it is impossible to assign responsibilities to bad officials and reward the good ones. The collective decision of the right to information constitutes one of the fundamental requirements to exercise the necessary control of acts performed by public authorities to be truly democratic. Democracy is the form of public authorities to democracy is the form of government based on public things par excellence, which involves from the very moment of choice of rulers to the forms of exercise of citizenship and decision-making. We must acknowledge that all information is relevant to citizens, particularly the one related to themselves, and that the information that everyone has a right to know is the public one, as citizens are they themselves their rightful owners. This is as important as recognizing that personal information that refers to their own vital existence is theirs. Monitoring bodies should be called upon to assume their role responsibly and effectively. They should not forget that it is in them and through them that people can assure their fundamental right to personal data protection. If those who are in charge of these control bodies do not exercise their duty responsibly and set themselves up as true custodians of law, they may well be accused of being characters who act consciously or unconsciously against the democratic ideal that in many cases is still weak in Latin America. It is desirable to advocate for a strong and vibrant society, civil society, able to request, verify, and enforce the fulfillment of important rules for the maintenance of democracies that have been so hard to strengthen and whose steps forwards are sometimes uncertain. The future is for the people and with the people. They are the true experts in these matters, in the sense that if technology rights and their environments are not useful for the betterment of their quality of life, they will have low efficiency and effectiveness in the democratic consolidation, whereas such consolidation is fundamental to the development of all social actions. The effectiveness and efficiency of this paradigm of e-government will not be sustainable without supervisory bodies that have investigative, surveillance, and enforcement mechanisms, as well as an appropriate structure and adequate budget. Therefore, as far as regulations on protection of personal data are fashionable worldwide, it is imperative to legitimate the system, which requires granting these control bodies the powers to monitor and evaluate the government's actions and enforce the law, enabling them to take the necessary measures to rectify deviations from the regulatory provisions. However, despite regulations are already consolidating their existence, we must not forget that the whole innovation process requires a period of adjustment. Looking at the regulations and also at the judicial decisions and legal doctrine, we can affirm that Latin America is undergoing a process of recognition of fundamental data protection rights and mechanisms to enforce them. Transparency, privacy, and security as government policies have also entered the political discourse and collective awareness. The progress that has been made and its consequences in the different legal system is undoubtedly transcendent. The vast majority of countries are facing the possibility of strengthening their systems. This opportunity implies the chance to increase the democratic legitimacy of governments and the democratic indexes. Therefore, the control bodies face the challenges, the obligation, and the responsibility to be nothing less than guardians of democracy. So, what's happened in Uruguay? In Uruguay's case, the Data Protection Unit set off in May 2009, 10 years ago. So far, it has successfully achieved significant learning experiences and has enacted an important number of rules and regulations. The unit has increased its activity regarding opinions to complain from citizens who feel their personal data has been violated because of the occurrence of unwanted and unwarranted interference. In this sense, many and varied developments have occurred in Uruguay at this point. Undoubtedly, the country has initiated a strong way forward in terms of public policy for the consolidation of fundamental rights, and particularly those linked to the trial of civil and political rights, especially protection of personal data, access to public information, and information security. Particularly in what concerns us, the institution created for the protection of the right of personal data is being effective and efficient. Public and private entities have recognized the Data Protection Unit as the guarantor of the rights of individuals and the entitled capable of sanctioning people or business when necessary. If we take into consideration the recent creation of the unit, the strength is even greater. The incorporation of Convention 108 to the Uruguayan legislation has become another significant milestone in the consolidation of efforts in these fields, as clear signal of the government's political intention to continue taking firm steps in the matter. Obtaining the status of an adequate country with the standards of the European Union has also been substantive in the consolidation of the national data protection system framework. In that sense, Uruguay decided to take actions to modernize the data protection law. Since January 1st, 2019, provisions referring to privacy by design and by default, proactive responsibility, and data protection delegates, amongst others, were incorporated to the original data protection law. These incorporations were inspired in the developments of both the GDPR and the Ibero-American standards in data protection. Moreover, the Ibero-American Data Protection Networks, which Uruguay is honored to chair, has been making efforts to collaborate in the consolidation of existing regulatory systems and to generate awareness on the need for regulatory provisions in those countries that still have not promulgated their laws. However, this must be done taking into consideration local idiosyncrasies without losing the focus of international advances that already verify certain empirical force. Uruguay is a small country in size and population, but very solid in its conviction and legal actions, particularly those that concern safeguarding and guaranteeing the rights of individuals. Hence, the right to protection of personal data is not considered as a marginal issue of the public agenda, but a very relevant one. Uruguayan citizens are increasingly incorporating protection of personal data as a fundamental right and to understand its value once they have experienced the benefits on their life. Thus, we can say that Uruguay is on an onward path. We have advanced rapidly to generate the operating platform to secure the exercise of the right to personal data protection, which is nowadays in a process of consolidation. The path is not so easy, especially when it comes to fundamental rights. However, as you all know, when the horizon is clear, there are endless ways to make it there. And the realization of fundamental rights is always a huge and regarding challenge. Therefore, as Goethe said, knowing is not enough, we must apply. Wishing is not enough, we must do. And that is our horizon. Thank you.
Thank you, Laura. Thank you very much. You are right in that regard that Uruguay maybe is not the biggest country in the region, but you have been able to put in place a very robust framework, and I think in that regard your activity, the activity of the agency is quite relevant in the context of the region. I would like now to pass the floor to Marcelo Drago, the president of the Chilean Transparency Council, and one of the main actors in this very fascinating process that Chile is living now, since they are now in modernizing the data protection law. Chile is a very relevant actor also in Latin America, and there is also an element I would like also to highlight is the fact that they has watching to the Pacific. So also Chile has a very strong relation with Asian countries. And so I think that the position, let's say, in the region is quite relevant in that regard. So I would like then just simply the floor is yours, Marcelo. Thank you. And I would like also in any case, if you can illustrate that, about a bit the current reform, the timeline, how the situation is evolving, and how can we expect in the near future. Thank you.
Thank you very much, Manuel. Thank you. Good morning, everybody. In this snowing morning, I don't know you, but I see the snow. I just think in Belgium, Dutch chocolates. But this is the right place to be when it's snowing. You all know I don't want to go to all these introductory issues, but we are in the middle or in the beginning. What we think of is the fourth industrial revolution, a data-driven and data-harvesting economy. An economy based on datification of each and every aspect of human life, even the most intimate. The processing of our personal data and metadata is one of the pillars of the new digital economy, a network of economic activities based on information and communication technologies, Internet of Things, automatization, big data tools, artificial intelligence, algorithms, autonomous vehicles, etc., driving changes in industrial production, banking, retail, health, urbanism. We talk about smart cities, energy, smart grids, education, cybersecurity, and media, just to name a few. our personal information is now one of the most valuable commodities. And it's been commodified for different actors and stakeholders involved in digital markets, being capable of extracting the maximum value from them. For this reason, data is now the new oil of the economy, and the data centers are the refineries of the new 4.0 industry. But we need an appropriate regulatory policy and technological environment to foster this economy. Given the global character of this economy, it is critical for countries to seek to play an active role in this environment to enable adequate legal, regulatory, and policy frameworks. And we have witnessed the emergence of regulatory models that recognize the importance of protecting users and data subjects in order to strengthen trust in digital economy, mitigate potential risks, and encourage the use of interoperable approaches and relevant international standards. And the focus must be in recognizing that digital users need to be empowered to control, to take control of their digital and online identities. What about the Chilean case? Basically, in this point, we are in the ice age, not because of today's snowing, but we have been there since 1999. Our current law is from 1999. In that point, it was a quite, modern law. Chile somehow has a leadership on that. In that point was one of the first law that took the subject in a systematic and substantial way, but Chile abdicated its leadership on privacy. And nowadays, our regulatory framework fails totally in terms of fulfilling international principles and standards, failing in short terms, failing to our citizens' expectations. Our current framework doesn't consider a proper national data protection authority, and it lacks of an effective enforcement regime, among other problems. But last government, I'm talking about the government of President Bachelet, sent a bill to Congress to update the Data Protection Act. And the current Chilean executive, now the President Piñera, introduced a major amendment to this bill of law, which is under the discussion at the parliament now. The main focus of this draft is to establish a modern regulatory framework. This is the third attempt in 10 years to modify this law, but we are confident that it will be the definite one. But, no, 1 second. But it was an important step last year also. The Chilean constitution was reformed, incorporating a special provision that guarantees individual data protection as a distinct and autonomous fundamental or constitutional right. This constitutional reform explicitly recognized the notion of information self-determination. We think we can catch up. We can move from the ice age to the age of the, if we really decide. There's a movie in Chile. It's called Chile Can. It's similar to the Yes We Can of Obama, but this is before Obama. It's a very bad movie, by the way. I'm not talking about this movie to encourage you to see it because it's a little shame. But they have a little message there that I want to share with you. It's a Chilean space program to place a Chilean on orbit, basically. It's in a very, South American way, a very, not very perfect way. By the way, he did it, and he managed to put a Chilean on orbit. But somehow it shows the Chilean resilience. When we propose something, we can move things. We can really move we can move things to some common objective, and little by little, this regulation is in the path to be a priority in the country, in the path to have a political consensus, and somehow to recover the leadership that we used to have in this matter in the past. In drafting this bill of law, there was a special attention to the regulatory frameworks that guarantee the highest standards, and at the same time strengthen the Chilean trade integration and participation in global digital markets. The GDPR and Convention 108, especially its modernized version, clearly offer defined models with enormous influence over diverse stakeholders, government, and private sector. GDPR and Convention 108 Plus rules and principles have inevitably become a benchmark in the drafting of our new law. We fully understand that this can allow Chile to be considered as a country with an adequate level of data protection. Such recognition, together with new business opportunities arising from free flow of data, personal data, will be underlying the leading role that Chile intends to play in the field of privacy protection, serving as a model for the countries in the Latin American region to raise their data protection standards. There you have the list of topics that the reform includes and are in the line with the GDPR and Convention 108. And basically, we're going to have a proper data protection authority in hands of the Chilean Transparency Council. In part, that is the reason the reason why I'm talking now here. But as well because the Chilean Transparency Council already have authority on privacy issues on the public sector, not the private, but the public sector. But now this competence extends to the entire economy and with proper tools on compliance. What about the Latin America? Our region cannot afford to lag behind the opportunities of the digital economy. We must move towards personal data protection model that, together with protecting people, allow us to enhance our economic insertion and development. A lack of regional harmonization implies that our countries cannot fully take advantage of the fourth industrial revolution. But Latin America is getting up to speed. Somehow GDPR is stimulating legal reform in South America. The new legislation in Brazil, the Argentinian reform that, of course, Eduardo is going to talk about. Laura already talked about the updating in Uruguay. And somehow, those are good examples of this trend. There's a willingness to establish one common data protection standard across the region. Laura already talked about the Ibero-American Data Protection Network that we approved in 2017, a set of principles that is in the Ibero-American Data Protection Standards. Those principles can be adopted by our countries to develop our national legislation. In the preparation of these standards, close look was made to most emblematic international data protection instruments, such as the OECD guidelines, Convention 108 and its protocol, Directive 95/46 of the European Union, the APEC privacy framework, and of course the GDPR. The current system for data protection is highly fragmented, with diverging global, regional, and domestic regulatory approaches. In this, it is necessary to encourage international compatibility and convergence in the regional and international approaches to data protection. Even though global convergence is hard to do, there's an increasing pressure for all players, from international and regional institutions, businesses, and citizens, for greater harmonization and privacy laws. The GDPR and Convention 108 are definitely two milestones in privacy issues, raising the bar for data protection law around the world. For the decades ahead, GDPR and Convention 108 will be the major guidelines in dealing with data protection. In fact, many countries in different regions and legal traditions are adopting these privacy standards, or will be very likely to harmonize their data protection rules with those of the EU and the Council of Europe. Here, the GDPR is seen as the strongest data protection regime in the world, leading many to hope that it will set a gold standard. and is already influencing a higher level of convergence. GDPR presents an opportunity to level scales and drive convergence in the adoption of high standards and setting up a genuine platform for interregional partnership. In this context, we welcome the recent adoption by the European Commission of the adequacy decision of Japan. This is the first adequacy decision under the GDPR, and this is establishing the world's largest area of safe data flows. We think this is a crucial step in setting global privacy standards. And this is particularly important for Chile, as it can provide some insights into synergies of the IPEC CVPR system and the GDPR rules. Like Chile, Japan is one of the 21 economies of the APEC Forum, and its major trade partners participate in the APEC scheme. Considering APEC's economic relevance, we want to understand the possible compatibility between these two models, the GDPR and IPEC model, its potential gaps, and how the two might work together. In this sense, we must analyze this decision carefully, and as it will give us insights about the baseline criteria that will support upcoming adequacy decisions within the GDPR framework. But while the overall evaluation undertaken by the European Commission does not require a level of protection identical to that offered within the EU, it is required a level of protection that is essentially equivalent. We think we need more clarity about what is needed in order to secure an adequacy decision and what are the specific criteria applicable. In short, the question is, what kind of scrutiny can we expect by the European Commission in this issue? It will be extremely advantageous for third countries interested in this adequacy process that the EU could conceive a capacity building activities in this particular area. It is evident that this kind of initiatives will foster and facilitate the spread of the EU privacy norms beyond the European borders. Muchas gracias. Thank you very much.
Thank you, Marcelo. One could say that if Chile ever, let's say, abdicated from his leadership role in privacy, I think you are now recapturing the position of Chile, and I think is what the developments in are quite interesting. And we expect that how to have soon this modernized law and to be able to be there at the moment. Now I would like to pass the floor to Eduardo Bertoni. Eduardo Bertoni is the president of the Authority for Transparency, the director of the National Access to Public Information Agency, and a very well-known person in the privacy and data protection world. And I would allow now simply to pass the floor, and also the same question that addressed to Marcelo before it apart in your presentation. You could update us on the recent data protection developments in Argentina, and also maybe to how do you see the timeline going forward in the reform of the law? Thank you.
Thank you, Manuel. Thank you for the invitation to be in this panel and to be a participant of this whole conference, these 3 days. I would love to be a president. My position is just director, which is okay. And let me start with a couple of general ideas on why, for me, harmonization and convergence of regulation is important today. And then I will give you some more granulation of those ideas in examples of what's going on in Argentina. So let's go. First general idea. All of us know that the protection of privacy is a fundamental right. It's something that we agree for many years is that the state have a specific duty, a specific obligation to protect fundamental rights. So if we think on privacy as a fundamental right, and we think in the obligation of the states to protect a fundamental right, today in the digital era, it's impossible to work on that protection without some sort of convergence, without of some sort of harmonization that allows us, data protection authorities, to protect data subjects that could be affected, and that violation sometimes doesn't happen in our territory. Second general idea. We know, particularly in Latin America, how important is development, investment, innovation in our countries. To attract foreign investors in this area is essential to work for an harmonization of the rules, conversion of the rules, because a balkanization of rules will affect this innovation and will affect this kind of investment. And investors that have the possibility to go to one country that have, very, very, very flexible rules, maybe will decide to go to that country, and other countries that really want to protect rights could be affected by that decision coming in another country. So those aspects means that conversion is not just important for the data subject, the protection of a fundamental right, but it is also important for investment, innovation, and development. So there are three components, in my view, that are essential for, making these ideas a reality. If we really want to have enforcement in a real enforcement, a globalized enforcement of data protection rights, the first thing that we need is to have strong data protection authorities, independent data protection authorities, that they will not be affected by pressure coming either from the governments and the private sector. So the idea of having independent authority is embedded in the GDPR, is embedded in the Convention 108+, and is essential, in my view. What's going on in Argentina on this aspect? Our constitution established privacy and data protection as a fundamental right in 1994 reform, in the 1994 reform. Then we had the 2000 data protection law in Argentina. And we were working all of this year until 2017 under an institutional framework that, frankly, was not very good in papers. I mean, the Data Protection Authority depended directly to the Ministry of Justice at that time. And even though it has been working, or it worked pretty well, the institutional design was not very well at all. That's why in 2017, Argentina complied with its international commitment to establish an independent authority. And the decision was to work in an institutional framework that is similar of the framework that we in Latin America have, for example, in Mexico with the INAI, or you have here in Europe, just to mention one example, with the ICO in the UK. That means having independent institutions that cover both access to public information plus data protection. There are a couple of things that are important to highlight here. Under the new regulations since 2017, the tenure is a fixed tenure, it's 5 years of the director of the agency, We have an independent, we have an autonomous and a specific budget for the agency that is in the national law that establishes the budget for the state. And something that is more important is that the removal of the director cannot be done just by the president who appointed the director, because the president needs binding or needs an approval coming from the Congress. That is a binding decision of the Congress if the president decided to remove the director. That gives the authority in Argentina the possibility to be stronger than it was in the past. And as I said, the importance of having independent authority for me is essential for the protection of human rights, of this particular human right, which is privacy, because if I decided to start an investigation about a specific issue in Argentina, a specific violation in Argentina, which we did, it's impossible to do that investigation if we don't have cooperations from other data protection authorities in other parts of the world. And then I jump to the second important point for the conversions and regulatory and harmonization of regulatory frameworks. Convention 108, in fact, is the only international agreement on data protection, a specific international agreement, in specific international treaty. So that's why we consider very important to be part of Convention 108. And the good news is that since the Committee of Ministers agreed to give a positive answer to our request, to an Argentine request to be part of the Convention 108, we finally, the Congress in Argentina finally approved Convention 108, December 2018. And just 2 weeks ago, I signed a recommendation to the government also to move forward to Convention 108 Plus. I gave a testimony in the Congress at least 4 times when they were discussing Convention 108. And one of the questions, both in the Senate and in the House, was why this is important for Argentina, why we need that convention if we have a good domestic protection, which is okay, which is true. I mean, our law was not, is a pretty good law. We need some sort of modernization. I'm going to talk about this in a minute. But we can say that the regulations are okay in Argentina. But so why? Why Convention 108? And my first answer was cooperation. Convention 108 and Convention 108 Plus establish specific rules that allows cooperation between data protection authorities to do investigations and to work globally in the protection of the rights of the data subjects. And then I moved to my last point today, which is why, or the necessity in all of the regions in this idea of harmonization and convergence, not only to, be part of an international agreement like Convention 108, but also to implement those international standards, those international agreements domestically. That's why we are working since 2016 in a new data protection law for Argentina. It was very interesting that it was not just the people who are working on the field of data protection that really want a modernization of the data protection law in Argentina, but it's a political decision. The president of Argentina, in his State of the Union in 2017, announced to the Congress that the decision of the executive was to send a draft to modernize the data protection law in Argentina. And the government comply with that, announcement just 4 months ago, when the executive sent to the Congress a proposal to reform the data protection law in Argentina. That took place in October 2018. So to end my presentation on very quickly, what's new? Is something new under the sun? I would say that the idea of having a new data protection law is to modernize what we already have. It's not only in Argentina that we have this law coming from the year 2000, but we also have a bunch of interpretation of the law and regulations and decisions coming from the Data Protection Authority and from some judges that complement what we had since the year 2000. So it's not fair to say that we are not modern enough, but it is important for us to move to a new general regulation. So territorial scope in the draft is clear now that we can act not only to data processors that are in Argentina, but also against data processors that are not in Argentina, but are doing data processing that involves Argentine data subjects. We consider very seriously the conflict or the potential conflict between data protection and freedom of expression and freedom of the media. So we establish some specificities that freedom of the press and freedom of expression should not be affected. Accountability principle is implemented clearly in this draft. We include in the draft, because this is something that we already included in some resolutions of the agency, but in the draft is included very clearly the necessity to do impact risk assessment in some situation, and also to notify the authority and the data subjects in the cases of data breaches. We worked on the consent issue, which is for us essential for data processing. However, we work in a consent that is more flexible. We are not saying that consent is not important, but it's more flexible, and we are trying to adapt the idea of consent to the digital age. We included specifically the legitimate interest as a legal basis for data processing. We also included other legal bases for data processing very clearly. It is in our current law, but it's more clear in the draft, like binding corporate rules or contracts. By the way, we just passed a resolution coming from the agency specifically on binding corporate rules, for example, that we allow, and we gave in that resolution guidelines to work on binding corporate rules. So it's something that it's possible now in Argentina, even though we don't have this draft passed yet. The idea of including the data protection official, data protection officer, is included in the draft, not in general, not for all the data processors, but for some specific situations. And finally, one thing that for us, and going back to the beginning, enforcement is important, and the problem of the current law is that the fines that we can impose are too low. So we updated the amount of the fines, and we modernize other kind of penalties that the Data Protection Authority can impose in cases of violation of the right. So thank you very much. This is in a very, very quick review what happened in Argentina, what we are doing, and I will be more than welcome to respond questions or receive comment. Thank you.
Thank you, Eduardo. Thank you very much. I would like now to pass the floor quickly to Isabela Ardala, that she's the legal manager in Colombia for Atento, and she will provide us with a business perspective on data protection developments in Latin America and their impact on the Latin American business community, and maybe also a quick reference to the current situation in Colombia. Thank you, Isabela. The floor is yours.
Okay. Thank you, Manuel. Good morning to everybody. Thank you very much for the invitation to this panel. I would like to start by telling you that I work in a sector that you may use every day in your life. Normally, when you speak with your insurance bank, with your telecommunications provider, when you order a pizza, normally we are on the other side of the line. So I work in Atento. Oh, it's not working? Sorry. Okay. So Atento is a contact center that has permission to make companies successful by assuring the best experience to their customers. Atento is the largest provider of customer relationship management and the business process outsourcing in Latin America and among the top 5 providers globally. Since 1999, the company has developed its business in 13 countries, where it employs 150,000 people. We have over 400 clients to whom we offer different range of services in multiple channels. Atento's clients are mostly leading multinational corporations in sectors such as telecommunications, banking and financial services, health, retail, public administrations, among others. The company positioned itself at the forefront of the digital transformation in its sector with the launch of Atento Digital, a global business unit to drive customer experience in a digital age. Atento shares trade under the symbol ATTO on the New York Stock Exchange, and since 2016 has been named one of the world 25 best multinational workplaces to work by Great Place to Work. As you can see, Atento provide these services. To provide these services, use different kind of information. I'm not going to get a detail of really what we are doing. I can answer you after what we really do, if you're interested to know much better. But we use different kind of information from the end users of our clients. That's why we're very committed to comply with the law in every country where we operate, especially in the treatment of the information. Because of the use of internet, social media, data analytics, Internet of Things, technology developments, the way in which individual users and companies exchange information has changed, and this leaves national regulators with a difficult task to implement national law to protect citizens' privacy, whose data is often located beyond national borders and scattered across various jurisdictions. Atento is present in Latin America in these countries, as you can see. All they have laws related to data protection, as we already heard from the other speakers in this panel. So I'm not going to get a detail as I had prepared before, just to tell that Argentina, Chile, Peru had special laws in data protection, as we already heard. Brazil, I think we are going to hear a little bit later, has also a law from last year. And Chile, well, is doing a bill, as we already see. So I'm going to get a detail finally in Colombia to save some time. And as you see, Colombia has a robust regulatory framework on data protection from its political constitution, and is based on and developed by many laws, decrees, and other provisions. I'm going to get a detail in the statutory law, the Comprehensive Law 1581 from 2012, given the need for a transversal framework for IVS data. The general regime for the protection of personal data was established by this law that guarantees IVS data right and creates special procedures for its effectiveness, information holders' authorization, use, treatment, circulation, disclosure, updating, rectification, and deletion of data. Likewise, a personal data protection authority with broad sanctioning powers was set up. This authority is the delegation of protection of personal data of the Superintendents of Industry and Commerce. This comprehensive law was regulated through a decree 1377 of 2013 that includes the principle of demonstrated responsibility, accountability that we already heard, whose implementation guide was prepared by the superintendents. This decree also creates a public directory of databases managed by this authority with the personal information subject to treatment that must be that all company must follow and fill in. The described data regime has followed the European regulations since 1995, then the UN nations on 2000, and now it's taking into account the GDPR in force last year. What I would like to take a point also is in the last line of the time, if you see in the slide, because recently, by document issued by the National Council of Economical and Social Policy, Compass 3920 of 2017, the Colombian government defined the policy, 2018, sorry, the government defined the public policy on the data exploitation, big data. And then Colombia has become the first country in Latin America and the 8th in the world to do so. The document allowed country to implement a comprehensive law to use data to generate social and economic development in Colombia. The policy has 4 basic themes: the generation of digital data, the culture of data, the human capital for data exploitation, and the legal, ethic, and institutional framework. Due to this, the ethical and legal aspects that arise with the exploitation of data, as well as the potential risk that emerge in this context, require the design of a legal framework to maximize the benefits and lessen the risks, allow cooperation between public and private sectors, and reinforces the protection of citizens' rights in the context of the increasing transformation. For private sector companies, adjust their procedures and contracts with employees, providers, clients is done by their own responsibility and capacity to fulfill applicable laws, granting engagement with clients and final users. But it would be necessary that local regulatory entities publish guidelines to help in that task because of their requirements and impacts that must be taken into account, especially, for example, the GDPR that has its enforcement not only in the European Union, but also where residents and European people are. So even if we in Latin America, we operate in all those countries, we have to take into account the GDPR as a company. Digital ecosystems are a key factor of competition in the markets. In Colombia, these ecosystems generate employment, investment, export trading, and require elimination of barriers that prevent the possibility of accessing and offering digital goods and services, including personal data and the possibility of moving them beyond natural borders. It is a reality the companies need to transfer data to conduct business efficiently and without territorial restrictions to optimize productivity, management, and business development. We all know that business moves faster than legal system. That's why it's a challenge to keep the balance between global real needs without barriers and the protection of citizens' fundamental rights of habeas data within a legal framework. Therefore, it's necessary to establish global standards that allow interoperability, accessibility, and use of secure, stable, and developed strategies for privacy and data protection. An example would be the global standards on personal data all over the world and adopted by countries and companies that maybe it's a dream, but for example, in Latin America, the standards of personal data privacy from the Ibero-American states network on data protection that we already have my colleagues are an example that should be wide exposed. On the same line, the European GDPR standards are also an example of convergence in the European countries. We can take also on mind the Asia-Pacific Economical Cooperation Privacy Framework, providing the organization to adopt binding self-regulatory mechanisms to ensure the implementation of protection measures. Finally, in Colombia, we take also into account the US principles. There are such laws related not specifically with data protection, but covers the privacy, security, and so on. And for example, Colombia takes also into account that maybe not for Europe, but for Colombia, the United States is a country with an adequate level of protection. And finally, I think that adopt globally something similar as international financial reporting standards on data protection field would be easier in order to have a same language on this matter in the world. The digital age has changed the way of doing business among countries. Border limits are not only political and geographic matter because of the use of internet and the digital times, which makes the way to apply the rule more complex. Nowadays, the frontiers are not only those that we have known through history, political issues, or sovereignty. They are taking another dimension. In a few years, we'll be communicating with men on Moon, or Mars, or on other planets, and then we're going to exchange data. So this deserves a mindset change, including how to establish rules. That's why I could say that actually, on digital times, the only boundary that we may have is the Earth. Limitations on international cross-border data streams may impose significant cost on local businesses and deter others from making direct foreign investments in the country. These costs are ultimately passed on to the consumer in the form of raised prices in services, reduced competitiveness in the global marketplace, and limited access to the most innovative and impactful goods and services. To develop a legislative framework to protect privacy and personal data by taking into consideration innovation, globalization, and allowing free flow of information but protecting people's rights at the same time is a real need for citizens, companies, countries, and also for regulation authorities to make more efficient their task all over the world. Thank you very much.
Thank you very much, Isabela. We are having a very, very interesting interventions from our speakers, and I would like to take the opportunity also, since we have Danilo here, if he could maybe make a short report about the current situation in Brazil. And I think that would be very important for our public to know how is the current situation, how could evolve in the short future, in the near future. Thank you, Danilo.
Okay, thank you, Manuel. I will abuse my position as chair and try to steal some minutes, very few minutes, just to give a very brief update on the Brazilian situation. As I believe most of you know, Brazil has now a general data protection law enacted. It was enacted in August last year, and will enter into force only in August 2012. But it's necessary not only to approve the enacted law, but to make several changes on the enforcement system which is being created. And the first thing I would like to remark is that Brazil has followed a kind of different dynamics related to other Latin American countries. It enacted its data protection legislation years after other countries with similar economies and social institutions approved theirs, and this may be caused by particular market reasons. Maybe the Brazilian internal market was bigger than others. The country didn't feel the urge to adapt to international standards, or maybe international standards were not so concrete a decade ago in order to make the legislator wanted to comply. And that's also that Brazil has had a particular incidence of consumer law on providing for a kind of data protection framework for over 20 years. And there's also the Internet Civil Rights Framework, the so-called Marco Civil Internet, which provided since 2014 with some regulation regarding digital privacy, which for some cover some needs. But it has also the fact that historically Brazil has kind of started a tentative of something that someone once called a tentative Latin America data privacy protection model with habeas data, which was followed by other Latin American countries in their constitution. Habeas data has not developed in Brazil as a data protection framework, but for other countries such as Argentina and others, for example, it created the framework that later developed into a data protection law. For some authors still mention some kind of Latin American particularity, which I believe doesn't exist as such anymore, but for some time ABS data and other efforts played a very important role on this. Brazil has, since the 70s, worked with some propositions and bills regarding information privacy. Basically, all of them were based not on specific data protection rules, but on computer and security information security rules. The data protection, the new general data protection law was approved in a process that started 9 years ago in the federal government. And it's an interesting case of convergence. For several years, Brazil seemed kind of unsure which path to take. And finally, Brazil decided for an approach similar to international standards, even to Ibero-American Network Data Protection Standards, and to GDPR-like legislation, in the sense that when the time came, the approach taken by Brazilian legislator was a kind of internationalist. It's not a consumer law approach. It was mainly based because basically most of other Latin American countries follow this path. GDPR was so influent, and there was an interesting case of alignment among different sectors in Brazil. In Brazil, the private sector, academy, and also NGOs converged themselves to support data protection framework, which was finally approved. And finally, I would only mention that the law, the General Data Protection Law, which we call LGPD, which is, there's convergence also on the four-letter acronym, or the name of the law. But the law which was approved has had its DPA vetoed by the president for formal reasons. And last month, on 70th, at the end of December, the then President Temer issued an executive order which has yet to be confirmed by the parliament, creating a DPA and changing several parts of the law. I just want to mention that this executive order, we call medida provisória, created a DPA which has some, let's say, problems. For instance, it's not independent, it's part of the Presidency of the Republic. The only major element of independence is the fixed term for all of its 5 directors, but there's no administrative nor financial budgetary independence. There's also the fact that the executive order weakens some parts of the law which was approved, such as the several parts regarding the application of LGPD to the public sector are weakened. The powers of the DPA are weaker now. It cannot audit, for instance. There are changes in several other points. For instance, for automated decisions, there's no need anymore for a revision to be made by a natural person, and also the facilitation of sharing of personal data between public and private sector. So there are some potential issues which can make the law weaker when it comes into force in 2012, and the discussion is on the new government and the new parliament, which will start its legislative process next Friday. Will have to deal with these issues, and in a sense, Brazil, even having a new data protection law, is still with an open door for changes, and a discussion will be very important and huge in this year.
Thank you, Danilo. Thank you very much. We are running out of time, so I would like to open the possibility to the audience to make a couple of questions, because we don't have too much time, but if you allow me, I would like to start with a quick question to Marcelo, because during his intervention he was mentioned that the first law did not, let's say, put in place a data protection authority, but now in the current law they are working to create that new authority. So, Marcelo, could you please tell us a bit how this new, the Data Protection Authority is going to be shaped in the framework of the new law?
Thank you. In the first attempt to reform this law, 10 years ago actually, the new Data Protection Authority was given to the Transparency Council. After that, that didn't work it out. After that, a new bill of law give the authority to a consumer protection agency, the Chilean Consumer Protection Agency. Didn't work it out again. And the third attempt that we are now, in the first version of this project, of this bill of law, they were creating a data protection authority from scratch, a new one, like the Spanish agency. But that was the proposal of President Bachelet. After that, President Piñera in May sent an amendment to this bill, giving to the Chilean Transparency Council the authority as data protection, as DPA of the country. Mainly because the independency of the agency, the autonomy. It could be like in the UK, like in Mexico, like in Argentina, like in Uruguay, in Germany at federal and subnational level, in Canada at a state level, like in Serbia, like I don't know. There's plenty examples around the world that this comes together, transparency or freedom of information with data protection, and we fulfill the characteristic to be independent. We are 4 commissioners appointed in a process that the President of the Republic proposed to the Senate. The Senate have to approve this proposal by 2/3 of the senators. This is the highest quorum for anything in Chile. The constitutional reforms are for that, and we can be removed from our position in 6 years. Only we can be removed by the judiciary, the power that didn't participate in the appointment. So we're fully somehow protected from external pressure, and that works very well with the government. The process, the timing of the process means it fixes in some way, somehow that is not fixed to the electoral or the political process. So always we're renewing by by halves. So we are somehow we are protected by in the political process. So we're going to have a proper authority with proper powers of with fines and procedures, very high fines, and the powers that you can see around the world. Mainly, with the discussion is about what is going to be necessary to be. To have permission of the judiciary, is to have some very intrusive measures. But we think that this system is going to work out for the Chilean Transparency Council. It's going to be, of course, an important reform, but we can, yes, we can, as we said, and we can do it. We already have a long week with the Mexican authorities to know how it's working there, and we think we can move to that very quick.
Thank you, Marcelo. Now, quickly, I think we still have time for 2 questions, please. I think that the micro is coming. Sorry.
Thank you. I was wondering, and maybe you, Manuel, can answer this. What has been Spain's contribution to the Ibero-American standards, or data protection standards, as the link between Europe and Latin America?
Okay, since very interesting question, but I think that since I'm the moderator, I think it would be maybe we have here one of the persons who contributed mostly to draft the Ibero-American standards, Eduardo. So maybe you could.
Well, actually, that's not fair, for the Mexican colleagues who were the ones who started with this process. I mean, why we started working on the Ibero-American standards at the level of the Ibero-American network, it was just because many of the countries in Latin America do not have laws, or in the case of Argentina, for example, that we have a law, we need some sort of modernization. So we decided to have something more local, not only to look at the GDPR or an international convention, and that's why we started working on the level within the Ibero-American network, and we paid attention. We paid very strong attention to the Convention 108 and particularly the GDPR, but we also have discussion about our local realities, and that's the results of the Ibero-American standard. We think that the Ibero-American standards, I mean, I remember that in the process that we were developing the standards, we have conversation with Manuel, with Bruno, Giancarelli, who is around, at some point, trying to, do some sort of compatibilization, that word exists in English, I don't know, harmonization between the GDPR. That means, yeah, that is for the moderator, not for me. I'm the president, remember that. No, but we working on some sort of harmonization, but we pay attention to our national realities as well. I don't know if I'm answering your question. We like in Latin America to talk a lot and sometimes not answer, so sorry about that.
Okay, let's, yes, please. The last, I think, I'm afraid we only have time for one question, even taking some additional time. Yes.
Thank you for the presentations. It was very interesting for me to see. And I've, a question to that point. Data protection and democracy is the theme of our conference. And for me, is the question how to foster inside the Cono Sur, America Latina, data protection without general regional integration. The Cono Sur is not a EU. It's a more or less broad integration, but not the same level. And the other point, and it relates to Danilo, Professor Danilo Doneda, how to guarantee data protection with rising authoritarian regimes. We have now a right-wing, extremely right-wing president in Brazil. And for me, it's frightening to see that the Data Protection Authority should be under his control, virtually. And how to guarantee data protection, that means how to guarantee democracy and data protection in America Latina.
Just taking into consideration that for the democracy problem in the end of the case is broader than the data protection provisions. So in some sense, if you have the worst scenario, data protection will not be our major problem at all. Unfortunately, it can happen. But anyway, from a data protection view, I believe that our effort has to be to consolidate the idea and make it clear the need and the urgency for an independent authority in order for, let's say, the independence of authority is linked to a fundamental right in European Charter of Human Rights, not for a specific reason, because the enforcement of that protection has special characteristics that makes it part of the framework of a fundamental right, and this has to be a major issue in our debate. I believe that as far as data protection framework is concerned, that's what we need to operate right now. And the other questions, we just hope for the best.
No, I'm afraid we are running out of time, so thank you very much and for your presence, and thank you also to the speakers for this really interesting, informative panel. Thank you.